I'd like to start reading from State v. Willie at 163 New Hampshire 532. We held that just as it is unconstitutional to increase a defendant's punishment because he refuses to admit guilt, so too is it unconstitutional for a court to draw an adverse inference of lack of remorse from a defendant's silence at sentencing. Because the only affirmative way for a defendant who maintains his innocence through the criminal process to express remorse at sentencing is to forgo his right to remain silent, using a defendant's silence at sentencing to infer that he lacks remorse generally violates the defendant's constitutional privilege against self-incrimination. The state said that their offer to reduce or offer a reduced sentence of 35 years if Adam Montgomery took particular action within the next 7 days, and his reaction to that reflected heartless, immoral, no remorse. You can imagine, anybody can, that somebody walking into a sentencing hearing for something where he maintains his innocence that he did not do would be a difficult situation. That person would be assisted by his counsel, who would understand that being vilified for something that you didn't do would be difficult, who would understand that when people are trying to throw him away forever for something that you didn't do would be difficult, and that he would be schooled in reactions and how to react and how to appropriately respond within this courtroom. The state was doing a stunt. They were seeking a reaction today from Adam Montgomery in the courtroom by their stunt for something that they said, give us 7 days, and then Mr. Montgomery, acting appropriate with his counsel's representation, was called heartless, immoral, and no remorse. Mr. Montgomery does not have to express remorse here for something where he maintains his innocence. It would violate his constitutional rights against self-incrimination. And talk a little bit about the use of priors, as argued in the state's memorandum, to elevate what is a sentence as a mandatory minimum that is extraordinarily high, and it is high because anytime a child dies, an innocent child dies, deserves a strong punishment. And the legislature has spoken with a mandatory minimum of that punishment. The lack of rehabilitation is what the priors are put on for. I don't think anybody can predict what another person would be like after 35 years of incarceration. To assume the lack of rehabilitation for prior records that occurred from the time that Mr. Montgomery was quite young, that many, fueled by drug and drug addiction that was introduced to his life by some of the very witnesses, family members, wives, who participated in maintaining his addiction and in a lot of the conduct that he did in the prior record. He is worthy of rehabilitation, especially after what would be the mandatory minimum under this sentence. The use of the remaining charges also are inappropriate here. You did not consider the charge of homicide at his prior sentencing on the armed career criminal charges that he faced May a year ago. But you did consider the armed criminal charges, or at least you didn't indicate that you didn't, and the state certainly argued that they should be considered as well. All of that conduct occurred in a relatively short time period, and while we dispute the probable cause, even the law says that you can consider the grand jury indictment as probable cause, which I think is completely inappropriate, but that is the law. However, his sentences on armed career criminal took into account both his prior and his subsequent gun charges. He's serving a sentence currently of what comes to be about 32, because he got 15 as a minimum on one, 15 as a minimum on another. The 5 years of the 7-year minimum on the final charge that you sentenced him on, you suspended 2 years. Didn't even totally give him the max on that, but certainly increased his sentence in your evaluation of his prior conduct, as well as the pending gun charges. Another issue I need to address, and I'm afraid we only addressed part of it in chambers, my fault. The names of the no contact order I don't have, so we don't have a position on that as far as the names. However, since the state has asked for an incarcerated sentence on each of the charges, I don't believe a no contact order can be issued on the charges under interpretation of current law. However, I will say that the names will be provided to Adam, and I can assure this court that Adam will not seek any contact with the Sorrell family. Sorry, family. So, what do you do for sentencing Adam Montgomery? Adam Montgomery does not dispute the time sought by the state for abuse of corpse and falsifying evidence. The state has requested maximum sentences on that consecutive, and Adam does understand that it affected the investigation and that behavior affects justice in the court system. And he does not dispute the sentences requested by the state on that. However, while he maintains his innocence, he also knows that you will be sentencing him on the other charges because he has been convicted, and any other action he takes will have to be after sentencing. So as to the other charges, while he maintains his innocence on each of them, he can't offer a sentence because no sentence would be fair for him to say that they would be fair when he is maintaining his innocence and he did not commit those charges. So he can't offer you something that's appropriate for them, but he would request that you take into account his objections to the memorandum, and especially his silence here at sentencing, as being an appropriate position to take when he is asserting his innocence. We request that the court issue a sentence that is less than what the state has asked, and that it make the remaining charges concurrent with abuse of corpse and falsifying evidence. Adam Montgomery did not kill his daughter, but when he discovered his daughter's death, he broke, and he did inexplicable things. Even he can't explain his actions. But eventually he pulled it together, and he was able to say goodbye to his daughter. And that's what he did. If I may have a moment, Your Honor?
Yes, you may.
actually. My co-counsel has reminded me of something, and again, this was something that was not in the sentencing memorandum, and it was last minute, and it is the stunt that was pulled by the state, and it is that plea offers, responses, negotiations are inadmissible, and I think that they are inadmissible for any purpose, including sentencing. Certainly, I know in other cases, if I was to say the state offered something pretrial and now they're seeking twice that, the state would shut me down under that rule, which, 410? 410. So I think that entire stunt should be stricken from the record as well.
Briefly, Your Honor, I made no such comment about plea offers that were made prior to trial in any way, shape, or form. When I called the defendant heartless, immoral, selfish, and unapologetic, and in doing so, it's about the two crimes that he has admitted that he has done. It's the falsifying physical evidence and it's the abuse of corpse, which he admitted and even told the jury that they could find him guilty of. Those are the ones relating to the placement of the body. There's no reason to hold on to that piece of information with regards to that. The statement is not offering anything because this completely lies within the hands of the court. The statement is to make the change of what the state's recommendation would be. It's not an offer of a guaranteed sentence in any way, shape, or form. And again, it's on those charges, the one where he does not maintain his innocence anymore. Falsifying physical evidence and abuse of a corpse. I think just separately, Your Honor, with regards to the victims that the state is asking for the no contact order, that would include Crystal Sorey and her family, S-O-R-E-Y. That would also include the Miller family, Your Honor, and that would be Harmony's brother's family, and as well as the Rafferty family. I can provide those spellings to the court monitor afterwards. I think those are the only additional things that the state wants to add.
Attorney Gotti, what do you say to the State v. Toll issue that's raised by the defense about the no contact order on stand committed sentences, where all of the sentences that you're asking for in this case are stand committed, but you're also asking for the no contact provision?
Your Honor, I think with regards to that, rather than to prolong this particular hearing, the state would then also ask for a $5,000 fine on each felony for that to be suspended for the period so that the no contact order can be obeyed during that time period. And if he violates the no contact order, then that could be imposed.
Suspended for what period?
I would say suspended for a period of, well, on the two Class B misdemeanors, I would say suspended for at least a period of 7 years upon the beginning of that serving of that sentence. And for the charge of second-degree murder, I would say beginning on for a 20-year time period, beginning when he starts serving that sentence.
Do you want to address that, Attorney Smith? I'm just thinking about that for a moment. I mean, Attorney Gotti, on that, the consequence of a violation of the order would be the imposition of the fine.
That's correct, Your Honor.
Okay.
For clarity in sentencing, I think 5,000 is illegal for any one of those charges, although certainly combinations of certain charges can equal that amount. I think it's 6 of one, half a dozen of another, because as I said, with regard to the family, Crystal Sorey and her family, Mr. Montgomery will not be reaching out to any of them.